G'day everyone, and welcome to the fifth of my 2-hour law videos. The previous 4 videos have now amassed nearly 160,000 views between them. How cool is that? That's an awful lot of students that I've helped to pass courses. I can tell because of the number of emails and comments that I get thanking me. I really value that. A surprising number of students have asked me to tackle negligence as a priority, so here it is. Negligence is actually a companion to my earlier video, Tort Law in 2 hours. You see, torts are divided into the intentional torts, which are the ones in the other video, and negligence, which is this video. Some university courses divide these into 2 subjects, torts A and torts B or something along those lines. So after reviewing this video and the intentional torts video, you'll have covered all of the basic torts material in 4 hours. Obviously, that's if I can manage to get this done in 2 hours. Shall I give it a crack? Start the clock. Now, I normally start these 2-hour videos with a little bit of historical context. I'm going to do that in a moment. But for negligence, I think it's more important that you start out by understanding the 3 basic components of a negligence action. If you don't get those in your head from the very outset, none of the rest of what I'm saying will make any sense at all. The 3 core elements of negligence are a duty of care, a breach of that duty, and damage caused by that breach. Let's look ever so briefly at those by considering a really simple scenario, a rear ender. So let's say I'm driving along on the way to work. I have an audiobook playing, perhaps something by Anthony Trollope or O. Henry. The car in front of me stops because of a sudden traffic snarl and I'm too distracted to initially notice. When I do notice, I jam on the brakes, but it's all a bit late and I end up in the back of the car in front of me. Nobody is hurt, but both cars are banged up a bit. Now, under negligence law, I will be responsible for the damage to both cars. Here's how we can tell. First, I had a duty. Every driver on the road has a very clear duty to concentrate on the traffic around them and to adjust their driving in accordance with that traffic. Second, I pretty clearly breached that duty. I wasn't watching. Third, my breach of that duty caused damage. Every time we look at anything to do with negligence, it all really comes down to those 3 elements: duty, breach, damage. So I want you to have them in mind right from the start. We're always going to be talking about duty, breach, and damage. Okay, so let's step back in time. Negligence is actually quite a recent development in the law. It's really only been around in anything like its current form since the 1930s. Before that, the main action in tort was trespass. Now, those of you who have watched Tort Law in 2 hours will know that trespass is both direct and intentional. So damaging someone's car is a trespass if you walk up with a stick and bash in the headlight. But what happens if the damage is either caused unintentionally or indirectly? Well, in those cases, back in the old days, the plaintiff was allowed to make what was called an action on the case. An example of such a case was Grote against Chester and Holyhead in 1848, in which the plaintiff sued for harm caused to them when the rail bridge they were travelling over collapsed. You can see that the harm to them was neither intentional nor was it direct, but surely they deserve some form of compensation. The term action on the case doesn't make an awful lot of sense from a modern perspective, so don't spend too much time trying to understand it. The point to note is that the common law was slowly groping its way towards an understanding that sometimes harm was caused either indirectly or unintentionally, and in certain circumstances the plaintiff ought to be compensated for that harm. Along into that scenario came Mrs. O'Donoghue, who in August 1928 met a friend at a cafe, never for one moment dreaming that she was about to write herself into the history books by putting herself at the centre of perhaps the most famous case of all, Donoghue and Stevenson. Her friend bought her a bottle of ginger beer. She drank it, and towards the bottom of the bottle, she began to see that there was something unusual inside the bottle. It turned out to be the decomposed remains of a snail, which had obviously crawled into the bottle while it was in storage, awaiting filling. She suffered shock and gastroenteritis, and she sued. Now, first and foremost, she couldn't sue in contract. For one thing, she hadn't bought the ginger beer, so she wasn't part of the contract. And even if she had bought the ginger beer, her contract would have been with the cafe owner, not with the manufacturer. She couldn't sue in trespass either because the manufacturer had not intentionally harmed her. And finally, she couldn't sue as an action on the case because, in a sense, the manufacturer hadn't even caused the harm indirectly. It could be argued that she had caused the harm to herself by drinking the contaminated ginger beer. Still, she sued anyway, and she was the right person in the right place at the right time. Her action ended up in the House of Lords, where their lordships, and Lord Atkin in particular, decided the law was due for a change. The court found that manufacturers of products did owe the ultimate consumer of those products a duty of care, particularly in circumstances where any intervening party, such as the distributor or the cafe owner, would have no opportunity to check or otherwise interfere with the product's safety. The court found that if a party was negligent in relation to that duty, then the party could be liable in tort. And so the tort of negligence was born. Once it was born, the tort of negligence became a surprisingly flexible and adaptive legal tool. It came on the scene at around about the same time that motor vehicles became popular, and from the very start, negligence has been the usual form of action taken by one party against another after a motor accident. Negligence is also the basis for virtually the entire personal injury law industry. As this area of law developed, insurance companies stepped in to assume a lot of the risk of negligence. Anyone who registers a motor vehicle must insure against damage caused negligently to third parties. Anyone with a business or anyone whose activities affect the public will usually be required to hold public liability insurance. In fact, there are dozens of specific instances of negligence which can be insured against. And the fact that the defendant is likely to be an insurer with a lot of money makes negligence a very attractive cause of action. Simply put, an insurer is much more likely to be able to pay out on a claim than is a private citizen. All of this led to a gradual increase in negligent claims, although a lack of records and the fact that many negligence matters settle make it impossible to really specify the increase. What we do know is that awards started to grow, and as a result, insurance premiums started to rise. And around the turn of the 21st century, there was either a crisis or at least the perception of a crisis, and this led to what was called the IP report. We'll talk about the IP report in a few moments' time, but before we do, the last general principle I want to outline is the distinction between negligence and criminal negligence. Many of you will be aware that a large number of the intentional torts line up with criminal offences. So the tort of conversion is very similar to criminal stealing. The tort of battery is very similar to criminal assault. The tort of trespass is very similar to criminal trespass. False imprisonment is very similar to the crime of deprivation of liberty. Well, negligence also has a criminal cousin called criminal negligence. And they work pretty much in the same way. There needs to be a duty, a failure of that duty, and harm as a result. The difference is that for criminal negligence, the duty must be really spelt out clearly in the statute, much more so than for the tort of negligence. And also for criminal negligence, the breach of duty must be sufficiently serious that it merits criminal punishment. In this video, I'm really only going to be talking about negligence as a tort. If you want to learn more about criminal negligence, then go have a look at my criminal law in 2 hours video. We're going to go back now to what was called the insurance crisis around 1999 to 2002, because this so-called crisis led to very substantial changes in negligence law. Basically, it caused negligence law in Australia to go from being largely prescribed by the common law to being largely a statutory area of law. Perceptions in Australia had been growing for some time that we were becoming a more litigious society, more like the United States of America, where some negligence judgments are just 16 different shades of ridiculous. Those perceptions seemed to coalesce when a company called HIH Insurance crashed. This led to a serious shake-up in the Australian insurance industry. Essentially, insurance companies had reached the view that they were not making enough money because they were facing litigation more often, because developments in the case law had made it too easy for plaintiffs to win, and because the awards given to plaintiffs were too high. Other insurers started to abandon the Australian market for these reasons. Those insurers which remained started to really jack up their premiums. The media caught onto the story, which was quite unusual really. One would hardly expect insurance to become the issue of the day in Australia, but it did. The media started to report about non-profit community groups and kids' sporting groups which were shutting down simply because they couldn't manage the increases in their insurance. There were also stories about medical practitioners, in particular obstetricians, charging large upfront surcharges simply in order to offset the increase in their insurance costs. Whether there was an insurance crisis or not, there was certainly the perception of an insurance crisis. A number of states began to move towards reform in the area of negligence law, but then the Commonwealth stepped in and appointed a 4-person panel of eminent persons, chaired by former Western Australian Supreme Court Judge and later New South Wales Court of Appeal Judge David Ip. Their task was not simply to review the law of negligence. Their terms of reference were very clear. They had to make awards tougher to get and lower in value. The terms of reference said, the award of damages for personal injury has become unaffordable and unsustainable as the principal source of compensation for those injured through the fault of another. It is desirable to examine a method for the reform of the common law with the objective of limiting liability and quantum of damages arising from personal injury and death. So the panel wasn't tasked with considering if negligence law was unfair. They were told it was unfair, and they were invited to find ways to fix it. They did so, and most of their recommendations would make absolutely no sense at this point in the video. But one key result was that each state and territory passed legislation which made negligence largely a creature of statute instead of a creature of the common law. In Queensland, that legislation is called the Civil Liability Act 2003. So when we study negligence, we have a hard task in a way, because we have to start and finish with the statute. And yet the statute wasn't just invented out of nowhere. The statute rests on 70 years of frenetic development by the common law. So you need to understand the common law in order to make sense of the statute. The task for me in this video is going to be finding the right balance. You have to understand the statute or you'll fail your exams. But if you don't understand the common law, well, you won't understand the statute. Okay, enough background, folks. Let's really get stuck into the law of negligence. The first and most fundamental principle of negligence law is that there must be a duty of care. A person is not necessarily responsible for harm they cause in circumstances where they have no duty of care towards the other person. If there's no duty, there's no negligence. Let me give you an example. Let's say there are 2 shops in one mall and they're selling the same product. One of the shops is doing great and the other one is at crisis point. If that second shop doesn't get enough sales today, they'll have to pull down the shutters tomorrow. I have money in my pocket. Actually, I probably have a card. Who carries cash these days, right? I have money in my pocket and I want to buy one of the products. Now, if I buy from the successful store, the result will be the end of the other business. So you can see that my decision will cause harm to that struggling business. But you could never say that I had a duty to avoid that harm, could you? I can spend my money where I like. And while I may be sympathetic, it can never become my responsibility that the struggling business failed. So if a person wants to sue for negligence, the first thing they're going to have to show is that the defendant owed them a duty of care. No duty of care, no negligence. A duty of care boils down to 3 elements. First, reasonable foreseeability. In other words, is it reasonably foreseeable that my action will cause harm to another person? Second, if it is reasonably foreseeable, is that person who's going to be harmed a person to whom I owe a duty? Are they of some category of people to whom I owe a duty? And also, is my action sufficiently proximate or sufficiently logically connected to their harm? Finally, if the harm is reasonably foreseeable and the person is from the right sort of category, then we ask, is it fair and just that a duty should be imposed on me? Or is there some reason why such a duty might be unjust? We're going to go into these 3 categories in a lot more detail now, starting with reasonable foreseeability. The idea of reasonable foreseeability is actually pretty simple. The idea is that if you know your actions might cause harm to others, then you have a duty of care to take steps in relation to that harm. If, on the other hand, the harm is not reasonably foreseeable, well then you obviously have no duty, because how can you possibly take steps to prevent harm if you have no idea that the harm could follow? The idea of reasonable foreseeability is actually older than negligence itself. This is one of the ideas that began as an element of an action on the case. The classic authority is called Heaven and Pender, in which Master of the Rolls Brett said, "Whenever one person is by circumstances placed in a position with regard to another, that every one of ordinary sense who did think would at once recognise that if he did not use ordinary care and skill in his own conduct with regard to those circumstances, he would cause danger of injury to the person or property of the other. A duty arises to use ordinary care and skill to avoid such danger." This idea was then taken up in Donoghue and Stevenson by Lord Atkin, who put it this way: "You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbour." Now, the fundamental common law position really hasn't departed from those two earlier cases. What it's done since then is to add a heap of detail. You see, if we take Lord Atkin's seemingly simple statement, three things fall out of it straight away. First, you have to be able to reasonably foresee the harm. Those of you who've studied a bit of law already will immediately recognise that this is what we call an objective test. So we're asking, in effect, would an ordinary person in the position of the defendant foresee harm arising from their acts or omissions? In other words, the more that foreseeing the harm would require special knowledge, the less likely it is to be reasonably foreseeable. Having said that, as we'll find out later on, if a person holds themselves out as an expert, then they'll be expected to foresee those things which an expert would reasonably foresee. So the first point is that reasonable foreseeability is an objective test. Next, returning to Lord Atkin, he says that the harm must be likely to injure your neighbour. Now, that's no longer the test, so don't go making a note of that and using it in your studies. The reason Lord Atkin's use of the word likely remains important is that you don't have a duty to address every single potential reasonably foreseeable harm. Some reasonably foreseeable harm is going to be so unlikely that you don't need to do anything to prevent it. That's the law, and we'll see that in more detail later on. At the common law, a risk is reasonably foreseeable if it is not far-fetched and fanciful. This is a pretty low bar. A risk could be pretty darn unlikely and still not be far-fetched and fanciful. So a risk which is unlikely but still not far-fetched and fanciful will likely create the duty. Also bear in mind that the defendant needs to foresee human behaviour, and humans are often, to put it bluntly, idiots. People disobey signs, they disobey rules, and so if harm is reasonably foreseeable to a person disobeying those rules, well then that may be enough to create a duty of care. Finally, Lord Atkin says that you only have this duty in relation to your neighbour. Now, the neighbour here was used in the biblical sense of the parable of the Good Samaritan. So a neighbour is a person you're connected to, not literally the person who lives in your neighbourhood. But Lord Atkin's choice of words almost forces us to adopt the words of Luke in that parable and to ask, and who is my neighbour? In other words, to whom do I owe a duty? Well, there have been a couple of approaches to working out the extent of what we might call the neighbour principle. And this is important because by defining the people to whom a duty of care is owed, we're really defining who will be able to take action successfully under the law of negligence. Perhaps more importantly, if we don't carefully define who can take an action in negligence, then nobody could ever safely do anything for fear that your action might have some consequence that for someone you've never heard of, through some mechanism you never imagined. So who is my neighbour? In relation to whom should I be thinking about reasonably foreseeable harm? One way to think about this I'll call the class of persons approach. In other words, sometimes you ought to know the actions you might take might affect a certain class of persons, even if you don't specifically know who they are. This is most obvious in product liability cases like the original snail in a bottle. If the manufacturer makes a defective product, then they know that out there's a category of people who are likely to buy that product or use that product, and therefore that group of people is likely to be exposed to any harm from defects in the product. But what results in this class of persons? What is it about each class of persons that makes them a group to whom a duty of care should be owed? The answer brings us to the second and far more important approach to understanding the neighbour principle, the issue of proximity. The concept of proximity is really quite simple. In general terms, the closer you are to a person, the more likely you are to have to consider the impact of your actions upon them. So to take an obvious example, if you're driving a car towards a pedestrian crossing, the people on that crossing are proximate to you. They are close to you. Because they are close to you, your driving is likely to affect them in a way that it's not likely to affect someone on the next street. However, in negligence law, the concept of proximity goes well beyond this physical proximity. It goes to what we might call consequential proximity. So if you can think of your action having immediate consequences, those consequences will affect other things, and those consequences will affect other things, and so on and so on and so on. Well, the people who suffer the consequences closer to you in that logical sequence are considered to be more proximate to you. Some examples from the case will help this to make sense. An obvious starting point is Donoghue and Stevenson itself. Mrs. Donoghue was physically nowhere near the ginger beer bottling plant when she drank the fateful and famous snail-flavoured ginger beer. However, from a logical perspective, the line from bottling to sickness was very clear. When the bottle left the factory, someone was going to end up drinking it. That was the whole point. And that person would end up drinking whatever was inside the bottle. So it was fair for the ginger beer bottlers to have a duty of care to the person drinking the drink. Mrs. Donoghue was logically proximate to the bottler. However, now let's say Mrs. Donoghue had been wearing a borrowed dress for her cafe date, and the ginger beer had caused her to throw up all over it, ruining the dress. Well, the owner of that dress has suffered harm as a result of the bottler's failure to take care. But the owner of the dress is far less proximate, aren't they? The bottler knew for sure that someone would drink the drink, and they might have reached the point of realising a contaminated drink would cause the person to throw up. But there's no way that they ought to have foreseen that the person taking their drink and throwing up would be wearing a borrowed dress. So there was less proximity and therefore less reasonable foreseeability. In Vol against Inglewoodshire Council, an architect did not properly follow the standards when designing a stage in a hall. Sometime later, the stage was in use and it collapsed, injuring a number of people. The High Court found that there was sufficient proximity between the architect and those who were injured. In essence, it should have been clear logically that people would end up standing on that stage, and that if it was not designed properly, it might collapse and they might be injured. There was sufficient proximity. In a case called Gensch and Coffee, a driver's negligent driving led to the injury of a police officer. The officer's wife saw him in the hospital with tubes coming out of him and overheard the staff saying that he was not expected to live. She suffered nervous shock. The High Court ultimately found that there was sufficient proximity here because the negligent driver ought to have been easily able to understand that if he badly injured someone, their loved ones might suffer from a shock. There was sufficient logical or consequential proximity. In a case called Chapman and Hurst, there was an initial traffic accident caused by Chapman's negligence. A good Samaritan, Dr. Cherry, stopped to help, and while standing there, Dr. Cherry was struck and killed as a result of negligent driving by Hurst, who drove upon the scene. The High Court decided that Chapman, the original driver, bore some of the responsibility for the harm to the Good Samaritan, because he ought to have understood that his negligent driving could result in somebody coming to his aid, and therefore being at risk on the side of the road. So there was sufficient logical proximity. Finally, on this point, we need to deal with an important case called Perre and Apand. This case is sometimes described as doing away with the notion of proximity in Australia, but the reality is slightly more complicated. In this case, a potato farmer, Apand, negligently allowed a potato disease to spread to neighbouring farms. The disease did not spread to Perre's farm, but because the disease was in the district, Perre lost a big contract to supply potatoes interstate. Now, the court found that Apand did owe Perre a duty of care. The court focused first on reasonable foreseeability, but then it also added in the idea that, especially in cases like this, where you're talking about losses and harm that occur through the operation of the economy rather than any physical harm, a defendant should not be exposed to what they called indeterminate liability. So if a negligent act sends harmful ripples through an economy, it's not realistic to impose liability for all those effects. The thing is, doesn't that sound an awful lot like proximity? Isn't the court really saying that the further away an effect is, in the sense of logical proximity, the more links there are in the chain of cause and effect, the less likely there is to be a duty of care? It seems to me that the court just repackaged the concept of proximity in different words. In any event, can you see how the question for the court is whether the plaintiff in the case is someone who the defendant ought to have foreseen as being at risk from their actions, either because they were physically right there or because of the logical connection between the defendant's action and the plaintiff's harm. Once this logical test is met, the next thing we have to ask is whether there's any consideration in fairness or justice which should relieve them of that responsibility. And there are a few ways in which this might happen. The first one I'll mention relates to what is called a joint illegal enterprise. So let's imagine for a minute that we have a gang of jewellery thieves. Their plan is to tunnel into the area outside a diamond vault and then to blow open the safe and run away with the loot. Only thing is, the explosives guy is not terribly good, and when he sets off the charges, the safe doesn't open, but 3 of his fellow gang members are seriously injured by the blast. So, should the explosives guy have a duty of care to the other gang members? I mean, there's clearly sufficient proximity, right? Well, it would be absurd for the law to come to the rescue of the injured parties in that situation. The answer is that they shouldn't have joined a gang of jewellery thieves, and so there's no duty of care. But how far do we take this? Should any taint of illegality at all be enough to remove duty of care? This was the question the court had to consider in a case called Gala and Preston. In that case, a group of young thugs had been drinking and partying, and then they decided to steal some cars and go burgle some houses. Clearly, a charming young group of citizens. The plaintiff was in the back seat of the car, sleeping off the alcohol. The young driver had also been drinking. The stolen car left the road and hit a tree, killing one of the occupants and injuring the plaintiff. Did the driver owe the plaintiff a duty of care at that point, given that they were in a stolen car and on their way to commit burglaries? Well, the High Court decided that there was no duty of care. Their reasoning was because, as a matter of logic, it is impossible to determine what standard of care is owed by one reasonable car thief to another. Stealing a car was inherently dangerous. One imagines that if they were in their own car and nobody had been drinking, then there may still have been a duty of care, even though they were on their way to a burglary. The whole area of duty of care in criminals has since been further modified by statute, and I'll discuss that shortly. The second public policy exception I'll deal with very briefly. It's known as the advocate's immunity. Basically, a barrister or a solicitor advocate cannot be sued for their performance in court. They do not owe a duty of care to their client. The reason for this is that the lawyer's highest duty is always to the court. One aspect of that duty is a requirement for the lawyer to bring an independent mind to each case. They can't really do that if they're under a duty of care to their client. Having said this, another duty that they have to the court is to give their client the best representation they possibly can, so the client's not left high and dry. The next fairness consideration, which I'll mention briefly, relates to the performance of public bodies, everything from the Parliament to police to military forces. It's very clear that decisions made by these agencies will potentially cause harm. To take a contemporary example, there are various opinions about what, if anything, the government should do about climate change. If the government continues to financially subsidise coal-powered electricity generation, then potentially the government is breaching a duty of care towards young people who may have to live their lives dealing with far more major weather events than previous generations ever did. However, if the government refuses to spend money on coal-powered generation, then the government may breach a duty of care to those who rely on cheap electricity, which is all of us. If we don't agree with the government's policies or priorities, then the response is doctrinally to be found at the ballot box, not in the law courts. In many cases this makes sense, but in some cases it may be quite unsatisfactory. One of the best known examples is a series of cases known as the Stolen Generations case, particularly Cabillo and Gunner against the Commonwealth. The courts found that there was no duty of care to stolen Aboriginal children due to this public policy exception. This consideration dovetails nicely in with the final exception, which relates to circumstances where the defendant is under another duty, which they must implement and which is inconsistent with the claimed duty of care. This happened in Shaw, Saville and Albion against the Commonwealth, where a merchant ship claimed to have been harmed by the negligent actions of a naval vessel during the Second World War, when the two ships collided in the night. The Navy ship's duty to obey its military duties meant that there was no concurrent civil duty of care. We're nearly finished with the common law concepts underlying duty of care. Before we move on to the statute, though, I want to cover two final points. The first is a warning about what we call circular logic. You see, in most negligence cases, there is harm. The harm is right there in front of everyone, and it's easy to see. It's all too easy to conclude that because there was harm, there must have been a duty to avoid that harm. Unfortunately, it doesn't work that way. The court has to do everything it can to put itself in the position of the defendant at the time of their action or omission. If we could start with the harm and work backwards, then we wouldn't really need the concept of a duty of care, because it would always be possible to find such a duty. The second has been implied by what I've already said, but I want to draw it out for you. It's not just enough to find that there was a duty of care, any duty of care, by the defendant towards the plaintiff. The duty of care has to relate to the actual type of harm which was caused to the plaintiff. So when we're talking about reasonable foreseeability, we don't just ask ourselves whether any harm was foreseeable, we ask ourselves whether the harm which actually occurred was foreseeable. And yet at the same time, we don't want to go too far with that. If a plaintiff is injured in a car accident by, say, getting a broken finger, they won't need to prove that the defendant somehow ought to have reasonably foreseen damage to their finger. However, they will need to show that the defendant ought to have foreseen that they might be physically injured. So all of that basically describes what the common law says about duty of care. You have a duty of care to avoid acts or omissions which you can reasonably foresee will harm a person. Reasonable foreseeability includes the notions of physical or consequential proximity, meaning that for harm to be reasonably foreseeable, the person harmed must be sufficiently connected to the defendant, either by physical proximity or by the logical consequences of the conduct. So now we turn to the statute, the Civil Liability Act 2003. If you start by brushing through the table of contents, you'll see that even though this is a piece of legislation about negligence, there's no section defining duty of care. Lots of stuff about breach, which we'll come to soon, but no section that says this is the duty of care which is imposed on people. So, in desperation, we turn to the dictionary in the Act, and we find that duty of care means a duty to take reasonable care or exercise reasonable skill, or both duties. But that doesn't really help us much, does it? It doesn't help us to understand, for instance, how proximity works. So we keep looking in the statute, and we find that just above that definition of duty of care, there's a definition of duty. Subsection A of that definition says that in the Civil Liability Act, duty means a duty in tort. That's a really complicated, long-winded way for the statute to basically say that when it comes to duty of care, we stick with the common law. The Civil Liability Act doesn't have a definition of duty. It remains, in essence, the product of the case law in Donoghue and Stevenson and all the cases which have followed. The Act does include some exceptions where a duty of care would exist, but the Act removes the duty. One of these is a duty of care for an obvious risk resulting from a dangerous recreational activity. There are relatively few decided cases on this, but from those which have emerged, it seems that obvious is a fairly stringent test. So, for instance, in Queensland against Kelly, the plaintiff ran down a steep sand dune towards Lake Wabi on Fraser Island. He lost his footing on the dune, plunged into the water, struck his head, and was rendered tetraplegic. On the way to the lake, he passed a sign with pictograms warning of the danger of rocks under the surface of the lake. Now, you and I might think this was an obvious risk, but in a thoughtful and detailed judgment, the Court of Appeal decided it was not. Most obvious risks associated with most sports are relatively minor risks. A cricketer risks being struck by a ball. A macrame enthusiast risks, rope burn or something. Relatively few recreational activities involve obvious risks of the type that might bring a person before the courts. However, if someone was a circus enthusiast and was learning to juggle burning batons or learning sword swallowing, then I suppose the risks of those recreational activities would be obvious. Next, a range of organisations such as the Queensland Ambulance Service, the Surf Lifesavers and the Royal Flying Doctors bear no duty of care when they're performing duties in emergency situations in good faith and without reckless disregard for the safety of the plaintiff. In other words, the law recognises that rescuers in these situations have to make life and death decisions in a split second, and it's not fair for them to be worrying about potential liability so long as they're genuinely acting in good faith. Beware, though, that on at least one occasion the courts in Queensland have read this section very closely. If the person harmed can sue someone other than the protected entity, then there may be no coverage. So in Roan Spray against Queensland, the plaintiff sued the state government with respect to injuries allegedly caused by the negligence of an ambulance officer, and she was successful. Next, there's a rather odd exception relating to food donors. So these are restaurants and the like which donate leftover food for the homeless. These organisations are protected from liability provided they inform the organisation to whom the food is donated of the proper storage and handling requirements for the food and the time within which it must be consumed. There's protection for volunteers doing community work organised by a community organisation. This is everything from umpiring kids' netball to handing out how to vote cards to door knocking for the Red Cross. There is no duty of care for acts done in good faith for one of those organisations. Basically, the idea here is to stop these organisations from being blown out of the water by insurance costs. While the section refers only to the volunteer being the individual, it seems clear now that the protection extends to the organisation itself. Next, when we were talking about Gala and Preston a few minutes ago, I mentioned that the statute has changed the rules for how people engaged in criminal activities can recover. Well, the new rule is found in section 45 of the Civil Liability Act. Basically, the rule is that there is usually no duty of care when the plaintiff was involved in committing an indictable criminal offence. For those of you who haven't yet watched my criminal law in 2 hours video, an indictable offence is one of the more serious ones. So this is not only people who are involved in a joint criminal enterprise, it also means that if, say, a burglar invades someone's home in the night, trips over and suffers a serious injury, well, the homeowner has no duty of care towards that person in negligence. If the court believes that this provision operates too unjustly, then the court can still award damages for negligence, but those damages must be reduced by at least 25%. Crime doesn't pay, kids. Finally, the statute now includes provisions specifically relating to intoxication. There are a few rules. The first, which we've already touched on with the common law, is that intoxication is irrelevant to duty of care. So the reasonable care that has to be taken by an intoxicated person is the same duty that they would have if they were sober. And it works the other way too. You don't have a greater duty of care to a person just because they're intoxicated. The second rule is if the plaintiff, the person who was harmed, was intoxicated at the time they were harmed, there will be a rebuttable presumption that there is contributory negligence. We're going to talk in some detail about contributory negligence later, but for now, let's just say if the defendant is drunk, they will have to prove that their intoxication was irrelevant to the harm they suffered. If they can't prove that, then their award of damages will be reduced. Next, if you rely on the care and skill of a person, and if you know or ought to know that they are intoxicated, then there is a presumption that your award will be reduced by at least 25%, unless you can show either that their intoxication was not relevant or that you had no other option. If you rely on that person's care and skill driving a motor vehicle, then the presumption is that your award will be reduced by 50%. Don't get in a car with a drunk driver, folks. So in short, the statutory approach to duty of care is to begin with the common law position on duty of care and then to remove that duty in various circumstances where the imposition of the common law duty was seen to be having a negative impact on the community as a whole. Let's summarise duty of care before we move on, shall we? We start with Lord Atkin's famous statement right back in Donoghue and Stevenson. You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbour. So the first test is reasonable foreseeability, which is an objective test. So we ask whether an ordinary person in the position of the defendant ought to have foreseen that their action would cause the relevant harm. The second test is essentially proximity. We ask whether the victim, the plaintiff, was sufficiently close to the defendant. This means either close physically or close in terms of the logic of cause and effect. We ask if the victim was sufficiently close, sufficiently proximate that the defendant ought to have considered the potential harm to them. If the victim is sufficiently proximate and if the harm was reasonably foreseeable, then we ask whether the duty of care was removed. It could be removed under the common law, either because the victim was engaged in an unlawful enterprise, or because the defendant was a barrister or solicitor engaged in court advocacy, or because the defendant was a public body implementing public policy. The duty could then be removed by the Civil Liability Act if the risk to the defendant was an obvious risk from a recreational activity, or if the defendant was an organisation performing public safety duties, if the defendant was a food donor, or if the defendant was a volunteer engaged in community service. If you have reasonable foreseeability and you have proximity and none of the exceptions apply, then you have a duty of care. If there's no duty of care, there's no negligence. If there is a duty of care, though, we move on to consider what the content of that duty was and whether the duty was breached. We begin thinking about breach of duty in exactly the same place where we began thinking about duty of care, with Lord Atkin in Donoghue and Stevenson, and his famous dictum that you must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbour. This time we're going to focus on the first part of that sentence. You must take reasonable care. So the court will ask, what would a reasonable person have done to take care in that situation? And did the defendant do those things? The first thing we have to note is that because this is an objective test, the court theoretically should not be too worried about factors individual to the person. And yet if the reasonableness brush is used too broadly, it may result in injustice. It may well be that a reasonable person in the prime of life and health might react to a certain risk entirely differently to a reasonable person who's aged and in a wheelchair. Feminist legal scholars have made the point time and time again that historically the reasonable person was in fact a reasonable man, and that there are no guarantees that a reasonable man and a reasonable woman might react to the same risk in the same way. One method that was developed to get around this was the idea that we would consider a reasonable person in the circumstances of the defendant. That sounds like an improvement, but if we took it to its natural conclusion, there would be a different standard applying to each individual person because all of our circumstances are at some level unique. So really, the law has to determine which characteristics of the defendant will affect the standard that they're required to meet, and which characteristics will be ignored. This is a value judgment, and it's one that can potentially be argued back and forth on a case-by-case basis. But here are a few general conclusions the court has reached in the cases. First, I want to talk about medical circumstances. In many ways in our modern society, we make reasonable adjustments to accommodate people with medical difficulties or mental illness or disabilities. However, in negligence law, those factors are often not relevant. So, for instance, if a person with a mental incapacity bears a duty of care towards someone else, they will be expected to meet that duty to the same level as a person without that mental incapacity. So in Carrier and Bonham, the defendant was schizophrenic and stepped out in front of a bus in order to attempt suicide. Carrier was the driver of the bus. He hit the brakes but still struck Bonham, injuring him but not killing him. The accident had a terrible impact on the driver, who was unable to face continuing employment as a bus driver. The driver sued and was successful. Bonham was held to have had a duty of care to passing drivers when he stepped onto the roadway. It was reasonably foreseeable that a driver would hit him and that the driver would be traumatically affected. Bonham therefore had a duty not to step in front of the bus. His schizophrenia was held not to be relevant. Similarly, in an earlier South Australian case called Mazinski and Backer, a driver who had only one eye was held to the same standard as a driver with two eyes. Essentially, the rationale was that if the defendant chose to drive, the defendant must bear the same duty of care as other drivers, as a driver with their vision intact. In the same way, a lack of experience will not change the duty of care. A person who is inexperienced in some activity will nevertheless bear the same duty of care as a person who is much more experienced. Now, these might both sound quite harsh. After all, a person with a disability may simply not be able to meet the standard of care which can be met by a person without the disability. And a person who's inexperienced certainly cannot discharge their duties in the same way as an experienced person. However, we need to bear in mind the purpose of negligence law, which is to say that a person's been harmed. If the defendant had a duty and they failed in that duty and harm is caused, then the harm affects the plaintiff just as badly, whether the defendant is disabled or inexperienced or neither of those things. The harm is the same, so the liability should be the same. This is quite different to the criminal law, where disabilities and inexperience would definitely be taken into account, because the criminal law is answering quite a different question. Negligence law is answering the question, should this victim be compensated? While criminal law is answering the question, should this perpetrator be punished? Having said that, the content of the duty of care does shift for one specific group in the common law, and that group is children. The law recognises that children are developing. It's also usually the case that children are subject to some level of supervision, whether immediate or otherwise. And so the standard required for children is the standard of a reasonable child of the defendant's age. A child of 2 years age will therefore bear virtually no duty of care, while a child of 17 will bear a duty of care essentially no less than an adult. And so in McHale and Watson, a 12-year-old boy sharpened a piece of metal. He threw it at a tree, but it glanced off and hit a young girl, ultimately resulting in the loss of her eye. He was found not to be liable in negligence, because while he had a duty of care to those around him, he was only expected to exercise the standard of care of a normal 12-year-old. Justice Kitto, in a judgment which reads very harshly 50 years later, said that by moving through society, we all take risks that we might be harmed by those around us, even if nobody was acting negligently. He said, one such risk is that boys of 12 may behave as boys of 12, and that sometimes is a risk indeed. McHale and Watson still expresses the law in Australia, but I honestly don't think it should. It doesn't seem fair to me that the little girl in McHale and Watson got no compensation, but if an adult had thrown the same item and hit her, she would have been substantially compensated. It doesn't seem like justice, but that's the current law. Finally, professionals and experts face a higher standard than anyone without that expertise. This makes sense. When you go to an expert, you're doing so because they're expected to perform to a higher standard than an amateur. I won't take this any further at the moment because we've got a whole section on these special duties coming up later. So where does this leave us? We're going to assume we have a duty of care. What must be done in order to satisfy this duty of care? Well, we must do what a reasonable person would do. And a reasonable person in this sense takes little account of the individual circumstances of the person unless they're a child or a professional. For everyone else, the starting point is to ask what an ordinary reasonable person would do in relation to the risk of harm arising from their actions. Well, what indeed? How do we work out what a reasonable person might do in relation to the risk of harm? This is one of the few areas in which American law has been very, very influential over Australian law. Because to answer this question, we still refer to what is called the calculus of negligence, first described by the famous and brilliantly named American judge Learned Hand. In a case called the United States against Carroll Towing Company, he said that in order to determine what a reasonable person would do in order to discharge their duty of care, we should consider 1, the probability of the harm occurring, 2, the gravity or seriousness of the resulting harm, and 3, the burden or cost or practicability of taking precautions to prevent the harm occurring. This test was then taken up by Australian courts. We're going to look at each element of the calculus of negligence in turn. But before we do, it's important that I let you know that while these are traditionally presented as probability, gravity, and cost in that order, the order is actually quite irrelevant. There's no logical sequence between them, and no one element is more important than the others. So let's start with probability. This facet of the calculus of negligence works pretty much how you'd expect. The more likely the harm is, the more you ought to do in order to prevent it. Some risks are almost certain to cause harm if you don't take steps to control them. So for instance, if you light a bonfire in the middle of a wooded area, in the middle of a dry summer, and you leave it unattended, a bushfire is all but certain. So you would need to take steps to prevent that damage, either by clearing ground around the fire, or more likely by choosing another night or another month, or another location for your bonfire. On the other hand, in a case called Bolton and Stone, a mighty cricket shot went for 6 and struck poor Miss Stone, whose house was near the ground. The evidence was that such a big shot was very, very rare, as little as once or twice a decade. The chances of such a shot not only being hit out of the ground, but also striking a person nearby, well, that chance was even smaller. In fact, the risk was so remote that the cricket club was justified in doing nothing. On the other hand, sticking with the cricketing theme, in the case of Miller and Jackson, the Miller's house was just 30 metres from the batting crease at one end of a cricket field. The club built a higher fence around the ground, but balls were still hit into their yard quite regularly, at least a few times each season, causing property damage and risk to the Millers. In this case, the risk was considered sufficiently high that steps should have been taken to prevent the risk. The other thing to keep in mind with probability is that it's a sliding scale. At one end, risk is negligible, nothing needs to be done. At the other end, harm is almost certain and the duty is very high. In the middle, though, there's that sliding scale, and obviously probability is a very imprecise concept in many cases. We can say that an outcome is very likely or somewhat likely, but it's going to be pretty rare for us to be able to say this form of harm has a 42.3% chance of occurring. So probability is almost always a question of fact between the parties. The general principle, though, is that the higher the probability of harm occurring, the more you should do in order to prevent the harm occurring. Now let's talk about seriousness. The cases often use the term gravity, but I know that I have many viewers from countries like India and Kenya where English may not be your mother tongue. One meaning in English of the word gravity is seriousness. The basic principle is pretty obvious. The more serious the harm is, the more you'll be expected to do to prevent it. So on the one hand, if we go back to our first cricketing case, Bolton and Stone, the harm from being struck by a flying cricket ball is usually quite minor. Especially at that distance, the likelihood that the ball would still be travelling quickly enough to do serious damage is pretty low. So nothing was really required of the cricket club. On the other hand, consider the case of Burnie Port Authority against General Jones. In that case, the Port Authority was building an extension onto the warehouse facility which it was leasing to General Jones. The building program included the use of insulation, which was hard to set alight, but it burned intensely and uncontrollably if it did catch alight. Welders who were working on the job inadvertently set the insulation alight, and the building was destroyed, including a large quantity of fruit and vegetables which were the stock of General Jones. In that case, the High Court observed that where the potential harm was massive, the obligation to prevent that harm was also massive. The majority judges said, indeed, depending on the magnitude of the danger, the standard of reasonable care may involve a degree of diligence so stringent as to amount to practically a guarantee of safety. So at this point we have two of our factors in the calculus of negligence. We know that the more likely something is, the more you have to do to prevent it, and the more serious a form of harm is, the more you have to do to prevent it. So at this point we really have four categories of harm, don't we? They're not exactly categories because each of them represents a spectrum, but it's helpful to think of them as categories. We have serious harm, which is likely. This is going to have the highest duty of care. Then we have serious harm, which is unlikely. That'll have a lower duty of care. Then we have minor harm, which is likely. That'll also have a lower duty of care. And finally, we have minor harm, which is unlikely. The duty of care here is quite small. These are the sorts of questions of fact which the court will likely consider when considering what a reasonable person would do to prevent harm in each case. But then we add in our third factor, practicability. Practicability asks the question, is there anything which could be done to reduce the risk or the harm? And if so, what's the cost of doing that? So for instance, let's consider a game of rugby. It involves heavy physical contact, and so it's reasonably likely that injuries will occur, and those will range from very minor to potentially very major injuries. Now let's imagine we have three ways of dealing with that risk. The first way would be by banning tackles in rugby, and instead replacing tackling with something else, like one player touching another. The second way might be by stopping play after every tackle or maul and having a doctor examine every player who had been involved. The third way might be by changing the rules to remove head-high tackling or sling tackles or other particularly dangerous types of play, while leaving the rest of the play undisturbed, and by having medical staff available to give immediate treatment if a player is injured. Now the first method, removing the tackles, is not practicable, because if you remove tackles, you no longer have anything which is recognisable as rugby. You have touch football instead. The second method is not practicable, partly because of all the delays in play from the doctor's checkups and partly because it would be very costly. The final method, however, is practicable. It reduces the probability of the risk, it reduces the likely seriousness of the harm, and it's something which can reasonably be done. In an example from the cases, Retsis and the Commonwealth, the plaintiff was injured when the blades of a circular saw came into contact with his hand. The Commonwealth, which was the employer, showed that there was no practicable way in which a guard could be placed between the hand and the blade, while still allowing the saw to be operated. Chief Justice Barwick in the High Court said, "The common law duty of care does not allow it to be said that there is a breach of duty to take reasonable steps to protect the employee against risk of harm from the machine when there's no practicable method by which all risk can be eliminated, or indeed where the risk cannot be reduced beyond the point where the use of practical expedients can reduce it." Now, as you can imagine, this involves some fine judgments on the facts. I mean, what seems like reasonable expense to the person whose hand was just chopped off might be entirely different to the perspective of the employer. However, it's not enough to say that a solution is merely expensive or inconvenient. The law is likely to hold that a reasonable person would endure some expense or some inconvenience in order to manage the risk to others. The question which will be at the heart of many negligence cases will be how much expense and how much inconvenience. The answer will often depend on the rest of the negligence calculus. So if you have a risk which is high probability and will cause significant harm, well then you'll be expected to endure substantial inconvenience and expense in order to mitigate that risk. If you have a risk which is high probability but low harm, or which has a low probability of causing substantial harm, then you'd be expected to endure some level of inconvenience or expense, and the precise amount will depend on the extent of the probability and the harm. If you have a risk which is low probability and which will cause little harm, then you really won't be expected to endure any significant expense or inconvenience. One final thing about the calculus of negligence though. The calculus has to be based on the knowledge of the defendant at the time. You see, quite often, the occurrence of an event, an injury or an accident, is the very thing which shows there was a risk at all. And in many cases where there's been a harm caused, the defendant might be inspired to implement some new procedure or make some new investment in order to control that risk. Well, the mere fact that they do that is not to be taken as evidence that they should have known about the risk earlier or that they should have implemented those new procedures earlier. If the court took that approach, it would have the effect of discouraging defendant organisations from taking steps to control risks until after the case ends. Well, that would be a rather unfortunate outcome. So that's the common law perspective on breach of duty. We ask, what would a reasonable person do in order to manage the risk of harm from their actions? We know that the reasonable person is an ordinary adult, unless they're acting with some professional skill or obligation. We know then that we need to consider the likelihood of a risk occurring, the level of harm which would arise from that risk, and the practicability of controlling that risk. And that by balancing these three factors at once, we can determine whether a reasonable person would have taken the steps in question. So now we turn to the Civil Liability Act. How does it handle this question? Well, it does so in sections 9 and 10 of the Civil Liability Act. These sections are really super crucial, so we're going to spend some time on them. In general, though, they follow the same line of thinking as the common law, which is why I've just spent so much time telling you about those common law principles. We'll start with section 9, subsection 1. A person does not breach a duty to take precautions against a risk of harm unless A. The risk was foreseeable, that is, it is a risk of which the person knew or ought reasonably to have known, and B. The risk was not insignificant, and C. In the circumstances, a reasonable person in the position of the person would have taken the precautions. Now, a lot of that will sound very familiar. Section 1A talks about the foreseeability of risk and describes it as a risk which the person either knew of or ought to have known about. That seems to be essentially identical to the position in the common law, wouldn't you say? Section 1C then applies that reasonable person test. However, it refers to a reasonable person in the position of the person, that is the defendant. Some people might be fooled into thinking this means the Parliament's encouraging the court to consider the individual circumstances of the defendant when deciding if the defendant has acted reasonably. After all, you might think if the defendant has one eye, then a person in the position of the defendant would also have one eye. The courts have since made it clear that it doesn't work that way. The new provision has been held to substantially restate the common law. So we're still talking about every adult having to meet the standards of an ordinary person. So to this point, the statute is consistent with the common law. The risk must be foreseeable, and a reasonable person would have taken precautions. The statute then adds in a further provision that the risk must not be insignificant. So this takes us back to the cricket cases. If a risk is insignificant, then you can't breach a duty of care in relation to that risk. The only difficulty with this form of words is that it doesn't really specify whether the risk needs to be insignificant in terms of probability or seriousness or both. In reality, though, to be insignificant, we can assume the risk would have to be both low probability and not terribly serious in its consequences. So then we go to subsection 2. Again, stop me if any of this sounds familiar. Subsection 2 says, in deciding whether a reasonable person would have taken precautions against a risk of harm, the court is to consider the following, among other relevant things. A, the probability that the harm would occur if the risk were not taken. B, the likely seriousness of the harm. And C, the burden of taking precautions to avoid the risk of harm. D, the social utility of the activity that creates the risk of harm. So A, B and C are basically the common law calculus of negligence: probability, seriousness and practicability, which the statute describes as the burden of taking precautions to avoid the risk of harm. But then the Civil Liability Act adds in that last element, the social utility of the activity which creates the risk of harm. This can really be seen as a response to the concern raised in the IP review about the exposure of small community groups to potentially huge liability, and groups like sporting associations shutting down because they could no longer afford their liability insurance. Essentially, this paragraph of the statute says that if an activity has substantial public utility, then it might be appropriate to accept a higher level of risk. In the cases, this tends to involve sports, which are often inherently risky at some level, but which are encouraged by governments because of the social utility they provide. So recently, in TAP against the Australian Bushmen's Camp Draft and Rodeo Association, the New South Wales Supreme Court found that the social utility of organising camp draft competitions was relevant to whether the organisers met their duty of care. That case drew on an earlier High Court case called Agar and Hyde, which related to rugby union. So potentially a person or organisation which incurs a duty of care for an activity which brings public benefit, well, they might have to meet a lower standard of duty of care than a person or organisation doing exactly the same thing but for personal profit or without the public benefit. So now we're going to move on to Section 10 of the Civil Liability Act. This section lays out three further principles. The first is that the burden of taking precautions to avoid a risk of harm includes the burden of taking precautions to avoid similar risks of harm for which the person may be responsible. This concept draws on an idea which the court considered in a case called Romeo against the Conservation Commission of the Northern Territory. In that case, the plaintiff was a teenager who, after being affected by alcohol, fell down a 6.5 metre cliff and she was left paraplegic. She argued that the risk of her doing this was foreseeable and that it could have been managed by fencing off the cliff top. However, the court noted that if that argument prevailed, the Conservation Commission and potentially the Northern Territory government would potentially be required to fence off many areas in public. And so the total cost of all that fencing had to be measured against the total risk. The second principle in the section is the fact that a risk of harm could be avoided by doing something in a different way does not of itself give rise to or affect liability for the way in which the thing was done. Now, this is a really good one. Let's say that a risk has been identified and there are three different reasonable ways of dealing with that risk. The defendant chooses one of those ways. It turns out that the harm is caused anyway. Well, it's still the case, isn't it, that they did what a reasonable person would do to deal with the risk. The mere fact that there was another way of dealing with it doesn't somehow negate the steps that they already took. In an interesting recent case called Gray against Coles Supermarkets, a Coles employee hurt his back while lifting goods off a pallet. He alleged that there was another way of moving those pallets which would have prevented the injury. The New South Wales District Court refused to find a breach of duty, in part because even though Coles didn't implement the plaintiff's preferred method of dealing with the risks of lifting heavy items, they did have a system, and the system that they had was reasonable. This is a really important principle because if this principle wasn't in place, a party would have to implement every potential control process for a risk, which would get very expensive very quickly. The third principle says the subsequent taking of action that would, had the action been taken earlier, have avoided a risk of harm does not of itself give rise to or affect liability in relation to the risk and does not of itself constitute an admission of liability in connection with the risk. Wow, what a mouthful. So this is a statutory expression of the common law principle that we mentioned a few minutes ago. If a defendant implements new measures to control a risk after an incident, that's not an admission that they should have implemented those measures previously. So overall, you can see that the statute really echoes the common law. We're asking, what should a reasonable person have done to control this risk? And we're answering that question by reference to the probability of harm, the seriousness of harm, the practicability of the control measure, and then under the statute, we're also considering the social utility of the action which carries with it the risk of harm. Okay, before we move on from breach of duty, I want to quickly deal with two other related issues, warnings and apologies. It makes sense that sometimes a sensible way to control a risk is by giving a warning about that risk. The warning allows people to change their behaviour in a way that reduces or avoids the risk. So if there's a cliff face, like there was in Romeo and the Conservation Commission, which I mentioned a few minutes ago, we could put up a sign warning people to stay clear of the edge, and that should reduce the risk of them falling. The problem is, though, that this duty to warn can spin right out of control. If you've ever watched TV in the United States, you've probably been as amused as I have about the number of warnings they're forced to stick on the end of their commercials. Sometimes the warnings take up longer than the actual commercial. Imagine you were going hiking in a national park. Can you even begin to think of the number of warnings they might have to put on a sign at the entrance? Everything from dehydration to drop bears. It would take you 2 hours and a master's degree to go through the whole list. Statute has now responded on this point by implementing the concept of an obvious risk, which is a risk that would have been obvious to a reasonable person in the position of the victim. The Act provides that there is no duty to warn of obvious risks unless A, the person harmed asks about the risk, or B, there is a specific duty under some other law to provide the warning, or C, the defendant is a professional and the risk is in connection with whatever the plaintiff is seeking advice about. So providing a warning is still a very sound way to deal with a duty of care, but there's no duty to warn of obvious risks. Finally, apologies. For many years, certainly while I was growing up, the conventional wisdom was that if you were in a traffic accident or something like that, you should never apologise, because this could be taken as an admission of liability. Now, it's highly doubtful that this was ever true. I can't find a report in a higher court case where a person was held to have accepted responsibility because they apologised after an incident. However, people really believed this, and so the social healing value of an apology, or the positive effect of someone expressing sympathy or regret, was lost. That wasn't very good for anyone. So now the Civil Liability Act makes it very clear indeed that apologies have no effect on liability. Say that with me again, folks. Apologies have no effect on liability. You're not admitting anything if you apologise after an accident. Okay, let's recap. We now know that to be liable for negligence, you must have a duty of care. That means the harm must be reasonably foreseeable to a person who is proximate, either physically or logically, in circumstances where no exception applies. If that duty of care exists, then you must take those steps which would be taken by a reasonable person to deal with that risk. To work out what that means, we use the statutory version of the calculus of negligence, which says we have to consider the probability of harm being caused, the seriousness of the harm that might be caused, the practicability of taking steps to deal with the harm, and the social value of whatever activity is causing the risk. If there is a duty of care, and if the defendant has not done those things which a reasonable person would have done to manage the risk, then we move on to the third and fourth elements of negligence, which we'll deal with together. These are called causation and damage. The idea of causation is pretty simple. There was a duty, there was a breach of that duty, and there was some sort of harm suffered by the plaintiff. But before the defendant can be liable, you have to show that the harm suffered by the plaintiff was caused by the defendant's breach. Because it might be that yes, there was a duty, and yes, there was a breach, but that the actual harm caused had nothing to do with the breach. Let me give you an example. Let's say that a driver negligently secured the load on their ute, and a furniture item fell off onto the roadway. 2 cars were travelling behind. The first driver turned the wheel hard to try and get around the furniture on the road. That driver ran off the road and their car was damaged. The second driver behind them was sending a text message and not really looking out. While they were texting, just as the furniture fell off the ute, their car drifted off the road, their tyre came off the side of the bitumen, and their car spun into a tree. Can you see how the first car's damage was caused by the ute driver's negligence? The second driver's damage might look to the naked eye like it was the same form of damage coming in the same incident, but in fact, the ute driver's negligence had nothing to do with the damage. They just shouldn't have been playing on their phone. Causation is the process whereby the plaintiff must show that the negligence of the defendant caused the harm which they suffered. At common law, the main test used to determine causation was called the but-for test. In other words, a court asked whether the damage would have happened but for the breach of duty. So in a famous case called March and Stromere, the defendants had illegally parked their truck in the middle of the road in the early hours of the morning so that they could unload fruit and veg for their market stall. The plaintiff, who was affected by alcohol, drove his car into the truck. He sued. Now clearly his alcohol level was one cause, but the damage would also not have been caused but for the fact that the defendants parked their truck where they did. So they were liable for part of the damage. However, the but-for test was never a strict test. It was one expression of the idea that common sense ought to or to be brought to bear on the question of whether the breach caused the harm. The statute expresses it rather differently. There are two elements. The first is that the breach of duty must be a necessary condition of the occurrence of the harm. We call this factual causation. The second is whether it's appropriate for the scope of liability of the person in breach to extend to the harm so caused. We refer to this, strangely enough, as scope of liability. Let's start with factual causation. What do we mean by a necessary condition? Well, the rules of formal logic tell us that if one event is a condition for another event, it can be either a necessary condition or a sufficient condition. A necessary condition is a condition without which the second event would not occur. So strangely enough, it is necessary. A sufficient condition is enough all on its own, without anything else to cause the second condition. So what the statute's saying is that we ask, was the breach necessary for the harm? Or would the harm have been caused anyway, even if the breach had not occurred? How do we work that out? Subsection 3 says that factual causation is to be decided subjectively in the light of all relevant circumstances. Well, again, this is sounding a lot like the common law, isn't it? We ask, using common sense, whether the harm would have occurred if the breach had not occurred. What all of this adds up to, in my view, is that the but-for test is still all the rage. If a certain breach of duty is a necessary condition, then the harm would not occur but for that breach of duty. The statute then says that any statement made by the person after suffering the harm about what he or she would have done is inadmissible. This is important because the person who suffered the harm might say, if there was a warning sign, I would never have gone near the edge of the cliff, so the lack of a warning sign caused my injury. Well, of course they're going to say that, but people ignore warning signs all the time. Sometimes the presence of a warning sign makes it all the more exciting to take the risk. So the evidence of the person who was harmed is really not all that helpful. There are three other things we need to consider when it comes to factual causation, though. First, it's not always the case, in fact it will often not be the case, that the breach of duty will be the sole cause of the harm. That doesn't affect liability. The person who breached the duty will be liable for negligence, even if the breach of duty was one among a number of causes. However, the award given against the negligent party may be reduced if there were other significant factors, and particularly if one of those factors was the negligent conduct of the plaintiff themselves. This concept is called contributory negligence, and we'll go into it in more detail later. For now, just understand that factual causation doesn't require that the breach of duty must be the sole cause of the harm. If it is a cause of a harm, that's enough for liability. Next, we have to talk about what is called a novus actus interveniens, or a new intervening event. Sometimes what happens is that there may be an initial breach of the duty, but then before that duty actually causes any harm, there may be an entirely separate act which affects the harm, either increasing or decreasing it. This is discussed in our key case of March and Stramair, but I actually want to return to one I mentioned earlier called Chapman and Hearse. That was the one where there was an initial traffic accident caused by Chapman's negligence. Dr. Cherry stopped on the side of the road to help, and then he was struck and killed by Hearse's negligence. Can you see how the injury, the death of Dr. Cherry, occurred as a result of the negligence of the second car? But we really can't say that the first act of negligence had nothing to do with it. I mean, after all, if Chapman hadn't run off the road, Dr. Cherry wouldn't have stopped to help, and Mr. Hearse wouldn't have run into him. Other times, though, the new intervening event might completely overtake the previous act of negligence, to the point where we can no longer say that act caused the harm. So, in an old Western Australian case called Martin and Isbard, a young woman was in a taxi driven by the defendant. There was an accident due to his negligence, and she sustained a concussion. The hospital, however, misdiagnosed her as having a fractured skull, and she was so anxious about this that she ended up in hospital for 2 weeks, and then she was unable to work for some time in her usual job as a bartender. The court found that the hospital's misdiagnosis was a new intervening event, and that the anxiety she suffered was due to that misdiagnosis, and not due to the taxi accident, which, after all, only left her with concussion. So there was still an award against the taxi driver, but it was much less than the full claim. So the next question is how the court works this out. How does it work out whether the new intervening event is merely the consequence of the original negligence or whether the new intervening event should remove liability from the original negligence? You can see that in Chapman and Hearst, the intervention of Dr. Cherry, which put him at danger from traffic, was the almost inevitable consequence of Chapman's original negligence. Whereas in Martin and Isbard, there was nothing inevitable about a concussion being misdiagnosed as a fractured skull. The final thing to think about with causation is what's called res ipsa loquitur, which is Latin for the thing speaks for itself. And honestly, guys, I don't care if I've mispronounced that. Res ipsa is argued when the link between the negligence and the harm is patently obvious, when there's no other sensible explanation for the harm other than the negligence of the defendant. However, res ipsa is a matter of logical reasoning rather than being a rule of law, and the plaintiff ultimately always bears the burden of proving that the harm was caused by the negligence. So in reality, while res ipsa might be pleaded from time to time, it'd be a fairly brave lawyer that relied on this doctrine. Much better to come forward with actual evidence. So we have our duty of care. The duty of care has been breached. The final question we have to ask is what sort of damage can be compensated in negligence? First up, unlike, say, the tort of trespass, negligence is not actionable per se. In other words, unless there's actually damage, then there's no negligence. You can fail to meet your duty of care all you like, and provided nobody gets hurt, there's no negligence. Nominal forms of hurt, such as anxiousness, embarrassment, and fear, are all just normal human emotions. They're not considered to be harm, and they're not compensated in negligence. Psychiatric injury, however, can be compensated. You might recall that we've already touched on Gentian coffee, where a police constable's wife suffered nervous shock after seeing her husband on the hospital gurney and hearing medical staff tell one another that he was not expected to live. But she ended up in a hospital with a diagnosed psychiatric injury. It wasn't merely being upset or being in grief. In a New South Wales case called Wicks against the State Rail Authority, along with Sheehan and the State Rail Authority, 2 police officers made claims for psychiatric injury after they attended the terrible Waterfall train disaster in January 2003, in which 7 people died and many people were injured. Now, that case related to provisions in the New South Wales Civil Liability Act, which don't exist in Queensland's legislation, but it's a good example of the sort of mental harm which is actionable. Under the Civil Liability Act in Queensland, mental disorders are simply treated as a form of injury. They're assessed using the same scale as any physical injury. I'll discuss that scale in a few moments. In some cases in negligence, a person is not injured, but property is broken. Those are usually the easiest ones to work out because the cost of repair or replacement will generally take care of the problem. The task for the court, in any event, is to assess the economic value of the plaintiff's loss. Finally, there is a type of harm called pure economic loss. This occurs when the plaintiff suffers no injury to themselves or their property, but instead they simply suffer a loss of money or a reduction in the value of their assets as a result of someone else's negligence. The case everyone cites is called Caltex Oil and the dredge Willemstad, in which the dredge damaged a pipeline. The pipeline was not owned by Caltex, so Caltex hadn't suffered any property damage. However, the pipeline was used by Caltex to move its products. Without the pipeline, Caltex was unable to operate, and so it suffered a loss. So you can see that loss was purely economic. Pure economic loss can be difficult to claim for because the plaintiff has to show that the defendant ought to have had them in mind as potentially suffering that loss. In other words, the loss still needs to be reasonably foreseeable, and that can be a tall order in the case of pure economic loss. Okay, before we come to an end on damages, I want to very quickly look at how general damages are calculated in Queensland. General damages are damages which generally compensate. So they cover things like pain and suffering. We can distinguish general damages from what are called special damages. Special damages compensate the plaintiff for a specific loss. So a hospital bill will result in special damages, whereas the pain of injury will result in general damages. The way general damages are worked out in Queensland is that there's a scale from 0 to 100, where 0 is a harm so minor that no compensation is payable, and 100 represents the gravest type of harm imaginable. The general damages payable will be based upon the score given to the plaintiff's injury. So we start with Schedule 4 of the Civil Liability Regulation 2014, which is a big long list of all different types of injuries, and it also gives the range of scores and the factors affecting where the injury should fall in that range. So the total or effective loss of a hand scores between 35 and 60 out of 100, depending on a range of circumstances. Quadriplegia scores between 75 and 100. Minor asthma scores between 0 and 5. See how it works? Now, working our way through this particular table would be a specialty even within the legal profession, so I don't intend to take it further here. But in general terms, that's how general damages are worked out. The final thing we need to consider here is remoteness of damage. You see, one person's negligence might cause a chain of events with one problem snowballing into another and then into another and then into another. In a logical sense, all of those events might be said to be, at least at some level, the result of the initial act of negligence. But common sense says that liability has to stop somewhere. Otherwise, the initial negligent party might end up being responsible for harm they know nothing about, to people they know nothing about. The rule which is applied in Australia arises from a case commonly called the Wagon Mound. What happened in this case was that the crew of the ship Wagon Mound negligently spilled oil in Sydney Harbour. Some waste cotton was floating on top of the spilled oil. Some dock workers were welding and sparks from the welding caught the cotton alight, and that lit up the oil, which led to severe fire damage to the docks and several ships. So can you see how one thing led to another, led to another? The rule which was established was that the defendant is only responsible for harm which they could reasonably foresee as arising from their negligent act. The word reasonably tells us that we're really talking about an objective test. Would an ordinary person foresee the harm which was caused? Of course, this test dovetails nicely with our original test for duty of care, which requires people to take measures to avoid harm which they can reasonably foresee. If the duty is to take steps to avoid harm you can reasonably foresee, well then it makes sense that the liability should only be for harm you can foresee. There is one slight exception though, and we call that the eggshell skull principle. You may have already come across this one in torts. Basically, you must take your victim as you find them. And so if the person harmed by the negligence incurs greater harm than most people would, because he or she is vulnerable to that type of harm, well then the defendant will be responsible for the harm actually caused to that person, not just the harm that would have been caused to anyone else. Okay, time for a recap. The first stage in any negligence matter is to ask whether there is a duty of care. In other words, whether it is reasonably foreseeable that my actions might cause harm to somebody, whether that person is proximate to me, either physically or logically, and whether there is any special reason why the duty should not fall on me. If there is a duty, we then consider what needs to be done to satisfy that duty. We focus on the four elements of the negligence calculus. We ask, how probable was the foreseeable harm? How serious was the foreseeable harm? How practicable were measures to control the harm? And what social value was there in the act that produced the risk? If the answer to those questions suggests that the defendant has failed to do enough to manage the risk, then we ask whether that failure caused the harm which is claimed. We start with the but-for test, but then we modify it if there was more than one cause or if there was an intervening event. We then ask whether the damage is of a type that can be compensated, either damage to property, personal injury, including mental harm, or pure economic loss. If the answer to all of those things is yes, and the harm is not too remote from the negligent act, then a claim in negligence is made out. But it's not game over just yet. We have one more question we need to ask, and that is whether any relevant defences apply. Defences work in much the same way that criminal defences do. First, the prosecution shows that all the elements of the crime are present, and then the defendant shows if there's a defence which excuses them from liability. In negligence, the plaintiff must first show that all the elements of negligence that we've discussed previously are present, and if they can do that, Then the defendant can show if there are any defences which excuse them from liability. We're going to look at a few defences. The first is what we call voluntary assumption of risk. This defence is no longer used very much, but understanding it is the gateway to a number of other defences which are more commonly used, such as the defences of obvious risk, inherent risk, defences relating to participation in sports and recreational activities, and the partial defence called contributory negligence, where the defendant says, well, yes, I was negligent, but your own negligence made the harm a whole lot worse. What all of these have in common is the notion of a person knowing that there are risks, but taking on themselves some level of responsibility for the risk that they're putting themselves to. The second family of defences I want to talk about are the Good Samaritan defences, where people are either trying hard to do good things or where people are responding to emergencies and therefore may not have enough time to properly assess and manage risks. The third type of defence I want to talk about is the application of an exclusion clause, where a party, usually in a contract, includes a term which excludes them from bearing any liability for negligence. So let's get stuck into it, starting with voluntary assumption of risk. You'll sometimes see this defence referred to as the volenti defence, which comes from the Latin phrase volenti non fit injuria, which means no harm is done to a willing person. The idea of this defence in its earlier form, in which it was still used regularly, was that the plaintiff could not claim damages in relation to a risk of harm arising from negligence, provided four conditions were met. First, if the plaintiff was fully aware of the risk. That usually meant that an intoxicated person, for instance, could not be said to be a volunteer, because one well-known effect of alcohol is that it changes our perception of risk. Second, the plaintiff has to fully apprehend the nature and extent of the risk. I'm darned if I can see any difference between this and being fully aware of the risk, but it's always listed separately. Third, the plaintiff's acceptance of the risk must be voluntary. This means that if they're under any sort of duty or compulsion to accept the risk, they're not a volunteer. So, for instance, in Ogwo and Taylor, the plaintiff was a firefighter injured while fighting a fire started by the negligence of the defendant. Lord Bridge of Harwich, in the House of Lords, said that to regard the firefighter as being a volunteer would be utterly repugnant to our contemporary notions of justice. Finally, the plaintiff must accept the whole risk. So, for instance, in Winter against the Commonwealth, the plaintiff was a motorcyclist leading police on a high-speed pursuit. A police officer placed their car across the road in a roadblock position, but then it seems that as the motorcycle tried to dodge the roadblock, the officer moved the car forward, causing it to collide with the bike. The court found that the plaintiff had accepted the risks of speeding on a motorcycle and accepted the risks of leading police on a high-speed chase and dodging a roadblock, but he had not accepted the risk of the police car moving forward and colliding with him. He had therefore not accepted the whole risk. However, if a plaintiff is fully aware of the risk, apprehends the nature and extent of the risk, and accepts the whole risk voluntarily, well, then there can be no liability. This whole area, though, has changed dramatically as a result of the IP report and the introduction of the Civil Liability Act. For starters, and this was mentioned a little earlier, sections 13 through 16 of the Act give us two new concepts: obvious risks and inherent risks. An obvious risk is a risk that in the circumstances would be obvious to a reasonable person in the position of the plaintiff. The idea is that people have a responsibility as they move about in the world to keep their eyes open for potential hazards and to avoid, if they can, coming to any harm. In Gantus against the Hawkesbury City Council, the plaintiff sued after she tripped on the uneven verge between a footpath and the grass next to the footpath. Justice Cullinan said there was no concealment of the difference in height. It was plain to be seen. The world is not a level playing field. It is not unreasonable to expect that people will see in broad daylight what lies ahead of them in the ordinary course as they walk along. No special vigilance is required for this. Section 14 of the Act says that if a defence of voluntary assumption of risk is raised for an obvious risk, then the plaintiff is assumed to be aware of the obvious risk. So, if there's an obvious risk, the starting point for the court will be to assume the plaintiff was aware of the risk and to assume that the plaintiff took their chances. This is different from the common law situation where the defendant would have to show that the plaintiff was fully aware of the risk, apprehends the nature and extent of the risk, and accepted the whole risk voluntarily. Finally, Section 15 of the Act says that there is no duty to warn of an obvious risk. This makes sense because if a risk is obvious, a warning is not necessary. So the defendant can still be liable for harm caused by an obvious risk, but the starting point for the court will be that the plaintiff was aware of that risk and took their chances. An inherent risk takes this line of thinking one step further. This is all in Section 16 of the Act. An inherent risk is a risk which cannot be avoided by the exercise of reasonable care or skill. The only duty which there can be in relation to an inherent risk is a duty to warn people about that risk. And this makes sense because our basic duty of care is to do those things which a reasonable person would do in order to avoid the harm. Well, if an inherent risk can't be avoided, then we hardly can have a duty to avoid it, right? In the cases, the courts themselves seem to confuse obvious risks and inherent risks. Perhaps the best type of example of an inherent risk comes from the medical world. Certain medical procedures carry inherent risks of harm. The medical practitioner has a duty to do their best to undertake the operation, and they have a duty to warn the person of the risks, and we'll talk more about doctors shortly. But if the person is warned about the inherent risk and they go ahead with the procedure, then they really are choosing to take their chances. Section 19 of the Act then says that there is no liability for the materialisation of an obvious risk of a dangerous recreational activity. This is another one of those provisions that was intended to relieve the insurance burden on sporting clubs. However, this provision hasn't stood up too well in practice. We've already talked a couple of times about State of Queensland and Kelly, where the plaintiff recovered an award despite ignoring 2 warning signs and running down sand dunes into water of an unknown depth. But then there's Windley and Garzaland, in which the plaintiff recovered an award after she fell at a 10-pin bowling alley. She stepped over the foul line and onto the slippery lane surface. This was still not held to be an obvious risk. In Pollard and Trude, the plaintiff recovered an award after being hit in the eye by a golf ball while playing golf, and after a warning had been shouted to him that the ball had been hit in his direction. All of those seem to me like pretty obvious risks, but according to the courts, none of them was apparently obvious enough. In truth, though, the real answer to all of this comes from the defence called contributory negligence. The idea of contributory negligence is that if a person acts in a way that a reasonable person would not act, and if by doing so they contribute to the harm which they suffered, well then they cannot get damages for that part of the harm which they themselves caused. Contributory negligence has been around for many years, since at least the early 19th century in contract law. So as a concept, this is actually older than the tort of negligence itself. In Australia, the modern authority is a 1999 case called Astley and Austrust. But that case is a super boring case about trusts and solicitors. I'd like to explain contributory negligence by going back to Windley and Garzaland, which I mentioned a few moments ago. This is the one where the plaintiff tripped after stepping across the foul line at a bowling alley. Now look at the facts from the perspective of the court. On the one hand, everyone who's ever been to bowling knows that you don't step over the foul line because the boards are kept very slippery in order to let the game be played. Bowling alleys have signs up warning of this. But it's also just a rule of the game to make the game fair that you have to deliver the ball before the foul line. On the other hand, though, this injury was caused during what was called a glow-in-the-dark bowling session, where the lights were all dimmed. So the foul line itself and the warning signs were less visible. It seems like both sides are at fault, really. And that's what the court found. So the court found that the bowling alley was responsible for 60% of the harm, and the plaintiff was responsible for 40% of her own harm. So the damages that she got were only 60% of the total award of damages. Under Section 24 of the Civil Liability Act, the court can actually decide that the contributory negligence is responsible for up to 100% of the harm. So a defence of contributory negligence can, in effect, defeat the claim completely. Okay, time's starting to press on us now. Let's move on to the second family of defences, which relate generally to people doing good things. We're going to move through this one fairly quickly. First and foremost, One aspect of Queensland negligence law which is truly terrible is that there is no protection for an ordinary person who, out of sheer human decency, stops to render first aid to another person in distress. Listen to that again carefully. There is no general Good Samaritan law in Queensland. And if you stop and help someone and it doesn't go well, you have no protection. Other states provide this protection. Queensland does not. Ridiculous. Section 16 of the Law Reform Act 1995 does provide protection for medical practitioners and nurses who stop to help at a scene, provided they do so without seeking a fee. Although realistically, these professionals usually have public liability insurance anyway. Section 27 of the Civil Liability Act, which I mentioned back towards the start of this video, prescribes a range of organisations whose purpose is to enhance public safety. Those organisations are protected from liability when they provide first aid or similar assistance in an emergency, so long as they provide that aid in good faith and without reckless disregard for the safety of the person in distress or anybody else. Section 26 of the Act extends this protection to individuals who are performing duties for those prescribed organisations. So, if a St John's volunteer provides first aid at a footy game, the St John's organisation as a whole is protected and the individual first aider is protected. But the good-hearted people who just help have no protection. Again, ridiculous. Finally, Section 39 protects volunteers doing community work organised by a community organisation from liability provided their actions are undertaken in good faith, they're complying with the relevant instructions of the organisation, and provided they're not intoxicated. Provided that their conduct is not criminal, and noting that they're not protected for activities where insurance is required. So, a dad who trots around the boundary line of an under-13s footy game as the boundary umpire and who trips over a spectator and harms them will be protected from liability. Somehow, that activity is worthy of protection, but the activity of stopping to help a stranger who is injured is apparently not worthy of protection. I'll say it one more time, it's ridiculous. The third type of defence you may have already learned about in contract law. For our purposes today, I'll simply say that where two people make a contract, they are entitled to include in that contract an exclusion clause, whereby one or both parties expressly state that they will not hold the other party responsible for any harm caused by negligence during the delivery of the contract. It's amazing how many standard consumer contracts include this clause, where you as the consumer basically promise that the service provider can be as negligent as they like without incurring any liability. It's fair to say, though, that the courts don't like these provisions. For one thing, the clause will usually have to be brought to the attention of the party who's promising not to sue. And second, the courts will read the provision contra proferentum, which means they'll read it strictly against the interests of the person seeking to rely on that provision. So any exclusion clause will have to be very clearly drafted and very clearly pointed out to the other party. Okay, so now we're at the end of our discussion of basic negligence matters. We know how to establish a duty of care. We know how to work out whether that duty of care has been breached. We know how to examine causation. We know what sort of damage can be compensated. And now we know about defences, in particular contributory negligence. In terms of a basic understanding of negligence law, we're now done. But before the video finishes, there are a couple more things to look at. Next, I want to look at special negligence situations. Situations in which the law recognises that the normal stock standard rules of negligence must be modified. By now you will have realised that the law of negligence can reach into virtually any area of human conduct. So it should come as no surprise that there are dozens and dozens and dozens of very specific negligence situations. Talking about each of them is well and truly outside the scope of a 2-hour overview. I do, however, want to mention just a few, which seem to come up very regularly in undergraduate courses. Those are the duties of statutory authorities, the duties of professionals, the issue of failed contraception, which is known as wrongful birth, and negligent harm caused to unborn children. First and foremost, statutory authorities. Now, statutory authorities, such as government departments and local councils, they're in a very difficult situation when it comes to negligence law. For one thing, they have set budgets, and they have to decide how to spend those budgets. Money they spend on one thing, they can't spend on another. Second, they are responsible to and must obey the elected politicians who sit above them. Traditionally, going back centuries, this area has mostly played out in terms of roadways and highways. Consider the position of a regional council in Australia. Inevitably, they will have to control thousands of kilometres of roadway. To keep all of those roads up to an ideal standard would be, in effect, impossible. So they prioritise their resources according to things like the amount of traffic carried by a particular road. The way the law responded to these duties was to develop two concepts which we call nonfeasance and misfeasance. In this context, nonfeasance occurs when the statutory authority doesn't do something that they could do. For instance, they might lay bitumen on a dirt road, which would make it safer. If they don't, that's nonfeasance. Misfeasance occurs where the statutory authority does something, but they do it negligently. At the common law, a plaintiff could sue a statutory authority in relation to misfeasance, but not in relation to nonfeasance. So you can sue if they've done something wrong, but not if they merely omitted to do something that they could have done. An example might help. In Hill against the Commissioner for Main Roads, a roadway was becoming damaged due to draining issues. The council kept patching up the road, but they knew the problem would be ongoing, and one effect would be what's called shoving on the road surface, which is a disturbance in the bitumen causing ripples. This shoving occurred, and the plaintiff came off his motorcycle when he hit the ripples. The government argued that this was nonfeasance because while they could have resurfaced the road and fixed the drainage issues, they were under no specific obligation to do so. However, the court found that merely patching the road instead of fixing it properly meant that the government had in fact repaired the road negligently. So this was misfeasance, and they were liable. Seriously, the distinction between misfeasance and nonfeasance does a lot of people's heads in. I promise it's not that complicated. If the government agency has chosen not to do something, it's nonfeasance. If the government agency has done something but done it negligently, it's misfeasance. The Civil Liability Act has added some additional considerations which are found in sections 35 to 37. The really important one is section 37, which says that a public authority is not liable for any failure to properly inspect the roads, nor for any failure to keep the roads in good repair, unless they have actual knowledge of a hazard. So if it rains heavily and a dirty great pothole opens up on a country road a day or so later, the council can't be liable for the fact that it hasn't yet inspected or fixed that pothole. However, if someone reports the pothole to them, they lose that protection and their response to the report must not be negligent. Okay, next let's talk about the liability of professionals. I've already touched on this earlier. Our normal negligence duty of care is based on the risks which an ordinary person would have foreseen. Well, I don't know about you, but when I go to the doctor, I want them to be a little more skilled and capable than an ordinary person. An ordinary person might not know whether that lump is something to worry about, but a doctor sure should. And so it makes sense that professionals, including lawyers, in relation to their profession, face a higher duty of care than normal people just going about their business. The common law position was that a professional had to exercise the standard of care which would be exercised by an ordinarily skilled professional within that particular skill or training. That rule is essentially still in place, although it's been clarified slightly by section 22 of the Civil Liability Act, which protects the professional if they acted in a way that at the time the service was provided was widely accepted by peer professional opinion by a significant number of respected practitioners in the field as competent professional practice, provided that that professional opinion was not irrational or contrary to a written law. The section also makes it clear that there doesn't need to be universal agreement within the profession. Provided a significant number of peers would consider the conduct to be competent professional practice, the professional will be protected. However, there is an additional duty, one which we've already touched on. This duty falls on medical practitioners according to the statute, but in reality, it's likely to be professional practice among all professionals. And that is the duty to warn. Under section 21 of the Civil Liability Act, doctors have both a proactive and a reactive duty to give patients both A, the information which a reasonable person in the patient's position would want, regarding the risks of a medical procedure, that's the proactive duty, and also B, the information which the patient themselves asked for regarding the procedure, that's the reactive duty. We're going to stay largely with this medical theme for a few more moments. The next issue I want to discuss is the idea of harm to a baby in the womb. Now, traditionally, a baby in the womb was not as yet a legal person. An unborn baby had neither rights nor responsibilities. But then the laws gradually started to change in this regard. Perhaps the first step was the recognition in succession law that a person making a will could leave things to an unborn child who was on the way, but not yet born at the time the will was made. The idea that the unborn could have rights has also made its way into negligent law. Essentially, the law here is pretty simple. If a person can reasonably foresee that their conduct may cause harm to an unborn child, then they have a duty of care to do what is reasonably practicable to prevent that harm. In other words, the same duty of care exists with respect to an unborn child as exists in relation to any other living person. This includes, at least in some circumstances, a duty of care from a mother to the child she is carrying. However, the child cannot actually sue for any harm they sustain as a result of that negligence until the child is actually born. In practice, of course, the harm is often not detected until after the child is born in any event. While we're thinking of the unborn, there's one last issue which honestly is really rare, but universities persist in lecturing on this issue, and that's the issue of wrongful birth. This occurs when a medical practitioner conducts a sterilisation procedure which fails, and there's a pregnancy after the sterilisation. In 2003, in a case called Katanak and Melchior, the High Court found that in such circumstances, the doctor could be called on to pay all the costs of raising the child, as these costs would not otherwise have been incurred by the parents. As you can probably imagine, governments weren't too keen on allowing that decision to stand. So now sections 49 capital A and 49 capital B of the Civil Liability Act state that if there is a negligently performed sterilisation or negligent advice about contraception, the court cannot award damages for economic loss arising out of the costs ordinarily associated with rearing or maintaining a child. Wrongful birth should not be confused with another negligent concept, an even more rare concept called wrongful life. This concept arose from the remarkable case of Harrington and Stevens, in which the plaintiff, who had been born severely disabled and whose father was suing on her behalf, sued the doctor who had failed to diagnose her mother's rubella infection while her mother was pregnant. Essentially, the argument was that by failing to make the diagnosis, the mother had missed the opportunity to terminate the pregnancy, and the child had been committed to a lifetime of pain, discomfort, and 24/7 reliance on others. This was a crushingly difficult case. Justice Callanan described it as a question that has exercised the minds of philosophers, theologians, scientists, legislators, and lawyers throughout the world. In the end, the court determined that there is no cause of action for wrongful life in Australia. But the leading judgment, that of Justice Callanan, is dripping with profound regret that the result would leave the plaintiff catastrophically disabled and unable to obtain compensation. On that rather sad note, we come to the end of our story about negligence. But because I like you all so much, I do have a little bit of really useful additional content to add. What I'd like to do in the last few minutes of this video is to go through my negligence flowchart, which takes all of the concepts I've discussed in this lecture and puts them into a logical flowing form, which should allow you to tackle pretty much any negligence question that a university can throw at you. So here's the flowchart. Let's walk through it in a moment. Now, the flowchart is only going to be useful to you if you already have some idea about the concepts of negligence law. This really doesn't teach you anything. It just sets it all out in what I hope is one clear, logical summary. So, in any negligence situation, the first thing we have to establish is whether there is a duty of care. If there's no duty of care, there can be no liability in negligence. If you don't have a duty, then obviously you can't be said to have failed to meet that duty. We ask three key questions to determine if there's a duty. We ask, would an ordinary person in the position of the plaintiff reasonably foresee that their action may cause the type of harm which is being claimed? This is an objective test. We're not asking if they themselves foresaw it, but if a reasonable person would have. To foresee the harm doesn't have to be likely, it just has to be more than far-fetched or fanciful. If an ordinary person would not have foreseen the harm, or if the harm was far-fetched or fanciful, then there's no duty and no liability in negligence. If the harm can be foreseen, then we ask whether the plaintiff, so the person who's harmed, was sufficiently proximate to the defendant, either logically or physically. Now remember, this concept of proximity was attacked by the High Court at one stage, but then they started using terms like indeterminate liability, which were really just proximity by another word. If the victim is so far away, either in distance or because a bunch of dominoes have to fall between the initial action and the harm to them, then there is no duty of care and therefore no liability. Finally, we ask if there are fairness-based reasons why there should be no duty of care. For instance, were the plaintiff and the defendant involved in a joint criminal enterprise? Was the plaintiff intoxicated and how did that affect the duty? Is the defendant a barrister or solicitor advocate being sued for their performance in court? Is the defendant a public authority where the negligence related to their public duties? Was the defendant under some other duty, which means it would be unfair to also impose a duty of care upon them? If the answer to any of these is yes, then there will be no duty of care and therefore no liability in negligence. Let's say there is a duty though. The risk of harm was foreseeable, the plaintiff was sufficiently proximate, and there was no fairness reason not to impose a duty of care. In that case, we move to our second key question and ask, what would a reasonable person do with respect to that duty of care? Again though, we're asking about a reasonable person, so it's an objective test. But it's an objective test with a difference. The person is both reasonably experienced and not under a disability. So inexperience or the disability of a defendant is irrelevant. They'll be expected to discharge the duty in the same way as anyone else. Children, however, are assessed at the standard of an ordinary child of that age, and professionals are assessed according to ordinary professional practice. To work out what that ordinary person would do, we apply the four elements of the calculus of negligence. We ask how probable the harm was. Generally speaking, the higher the probability of harm, the more the defendant should do to avoid it. We ask how serious the foreseeable harm was. Generally speaking, the more serious the harm, the more that should be done to avoid it. We then ask how practicable are the control measures which could control the risk. How expensive are they, and do they make common sense in the overall context of the situation? The overall situation includes the whole duty upon the defendant, and not just the duty isolated to the specific place or the specific incident. Generally speaking, a defendant will be expected to do that which is practicable, but they will not be expected to do that which is not practicable. Finally, we ask about the social utility of the activity which produces the risk. Risks which produce valuable social outcomes are more tolerable than those which produce only private outcomes or negative social outcomes. The combination of those four factors, with none being more important than the other, will result in a level of duty which must be met. We then ask whether the defendant did those things which a reasonable person would have done in order to discharge the duty. That doesn't mean they had to do everything logically possible, and it also doesn't mean that they're in trouble because they chose one possible method to deal with the risk, but there were other possible methods. Provided they responded to the risk in a reasonable way, then there's no liability for the harm which was caused. If, however, they did not do what a reasonable person would have done, then we have to ask what harm was caused. If it was physical harm, then the harm will need to be properly diagnosed, and it'll be assessed in Queensland on a scale from 1 to 100. If it's harm to property, then the harm will be calculated on the basis of the loss of value of the item or the cost of repairs. If it's mental harm, then the mental harm must be a psychiatric or psychological injury, not just an emotional reaction or a sense of discomfort. The psychiatric or psychological injury will then be assessed on the 1 to 100 scale, just like physical injury. Once we have clearly identified the harm, then we must ask whether the breach of duty caused the harm. Or more clearly, was the harm caused by the materialisation of a risk where the breach of duty was a failure to take reasonable steps to control that risk? To do this, we start out with the but-for test and ask whether the breach of duty was a necessary condition of the harm. If the harm would have happened anyway, breach of duty or not, then the breach did not cause the harm and there will be no liability. The test is more complicated though when there are multiple causes or when there's some sort of intervening event after the breach of duty but before the actual harm. At the end of the day, the court applies common sense when making its findings of fact in these situations. Bear in mind though the eggshell skull principle. If the victim has some particular vulnerability so that the risk harms them more badly than it might have harmed someone else, that vulnerability is not considered to be a contributing cause of the harm. If the harm does seem to be logically connected to the breach, the final step is to consider whether the damage is too remote. If there are too many steps between the breach and the harm, too many dominoes have to fall, then the harm will not be considered to have caused the breach. Let's say it is though. Well, now we have a duty of care. The duty of care has been breached. There's a harm, and the harm's been caused by the breach. The basic elements of a case in negligence are therefore in place. Next, we ask whether there is a defence available to the defendant. First, did the plaintiff voluntarily accept the risk? Bear in mind that if the risk was an obvious risk, they may be assumed to have voluntarily accepted it. If they did, then there's no liability. Second, was the risk an inherent risk, one that could not have been avoided? If it was, then there's no liability, provided an appropriate warning was given. Third, was the risk an obvious risk of a recreational activity? If it was, then there's no liability. Fourth, was the defendant a protected person or organisation delivering emergency medical care? If so, there will be no liability unless they were grossly negligent or they acted in bad faith. Fifth, was the defendant a food donor organisation? If they were, then their liability is restricted so long as they provided the right information about the safe handling and consumption of the food. Sixth, was the defendant a volunteer in a community organisation? If so, there will be no liability for anything they do in good faith as part of that organisation. And finally, was liability excluded by any contractual provision? Bear in mind that if there was such a provision, it can't be lurking in the fine print and it will be construed contra proferentum, or strictly against the interests of the party relying on it. If none of those defences apply, then the very final thing we have to consider is whether there was contributory negligence. In other words, did the plaintiff do anything to contribute to their own harm? If there is contributory negligence, then the court will apportion liability between the parties. Or to put it another way, the award to the plaintiff will be reduced by whatever percentage the court decides actually relates to their liability. If, however, there is a duty of care, the duty of care has been breached, there is harm, the harm was caused by the breach, no defence applies, and there's no contributory negligence, then the defendant will be completely liable. Okay, gang, at this point, let's stop the clock. That's negligence. It's pretty simple in concept, isn't it? Do what's reasonable to stop your actions from harming others or compensate them for the harm. Out of that simple statement, though, comes a whole area of law. Now, as ever, you do need to bear in mind that a 2-hour law course is no substitute for a whole term study. This is an introduction or a revision. Negligence is one of those areas of law which has a whole lot of tricky little twists and turns, and there's just no substitute for doing the hard yards. I do hope, though, that this video helps you to get started. Best of luck.